Very good afternoon to each one of you, distinguished colleagues, friends, and justice champions across East Africa and beyond. It is my absolute pleasure to welcome you all to this timely and powerful conversation hosted by East Africa Law Society in partnership with the Tanzania National Death Penalty Abolition Coalition and the World Coalition Against Death Penalty. So we meet just 2 days before the World Coalition Against Death Penalty. We know it will be on 10th this week, and there could be no better moment to pause, a moment to reflect, and to ask ourselves, like, what does justice look like when it chooses life over death? So as East Africa Law Society has always stood where justice breathes and humanity speaks, we convene this discussion because the death penalty is not merely a legal issue, it is a moral and a human question. So if the law is there to serve the people, it means it must listen to the heartbeat of the humanity. And this is why ELS is here, to make sure that the law does not just exist, but it evolves. So before we proceed, allow me to bring greetings from our CEO, Mr. David Sigano, and from the president of East Africa Law Society, Mr. Ramadan Abubakari, both of whom they convey their appreciation to our partners, to our panelists, and to all participants today. Now, I am simply your foundry moderator, and my good names are Tunsubilege Boniface. My friends call me Tunsu. And I promise to keep us on time and on topic, because, as I'm speaking right now, it reminds me of my professor used to tell me, a good moderator is like a referee in a football match. If you notice them too much, it means they're probably doing it wrong. So I'll try to do it just right. So before we begin, I have short housekeeping rules. Please make sure your microphones are muted when you're not speaking, and feel free to use the chat box to post your comments, your reflections, your country experiences, because we'll be following them closely. And another thing is that this session is being recorded to support learning and sharing. So keep your video on if possible. We would love to see your engagement. Today, we are deeply honored to be joined by outstanding line of speakers, of which each one of them bring a unique experience, a unique conviction, a perspective of this regional discussion. With us, we have Advocate William Ernest Kivuyo, who is the Executive Director of Pan-Africa Legal Empowerment Initiatives. In short form, it's called as PALEI. It's a regional networking advancing access to justice, to human rights, and public interest litigation across Africa. But also, he's a distinguished Tanzanian lawyer with extensive experience in constitutional and human rights law, and he has contributed to several landmark cases before national, regional, and continental judicial bodies. So his work reflects a deep commitment to strengthening African jurisprudence and to the very best of this conversation today. We also have Ms. Rose Ngunangwa from TAMCOD. TAMCOD stands for Tanzania Movement for Community Development, where she leads initiatives focused on legal empowerment, on gender, justice, and community awareness. So she has an extensive experience in civic education and advocacy, but also she has worked closely with national and regional partners on right-based reforms. But also, Ms. Rose is particularly passionate about public engagement and building community voices around justice and human rights. With us today, we also have Mr. Geoffrey Mayamba. He's Executive Director of Prisoners Future Foundation from Zambia. He continues to champion justice reform, rehabilitation, and dignity for persons in conflict with the law. But also with us today, we do have Mr. Okot Robert. He's a Ugandan human rights advocate and communication strategist with extensive experience in legal practice and right-based advocacy. So his professional brings it bridges the fields of law, governance, and media using strategic communication to promote justice reform, civic awareness, and human rights protection. And Mr. Okot has worked with several national and regional organizations on advocacy campaigns and capacity building initiatives, focusing on making complex justice issues accessible to the wider public. Last but not least, and this was in no particular order, we also have Mr. Gabriel Achai. He's the programs officer at East Africa Law Society. His presence in this regional platform is often reflects ELS's spirit. He's thoughtful, practical, committed to building a more just East Africa. So to each one of you, welcome, and thank you for lending us your wisdom today. And we will begin with short presentations from each speaker. And to our audience, this is your space too, not just because I haven't given you time to introduce yourself. Just feel free to drop your reflections, your insights, or even a quick applause emoji in the chat box, because this is not a lecture. It is a living conversation, and every good conversation is a good company, and that good company today, it's you. So now for those who have attended our previous ELS webinars, you'll know that Gabriel Achai is usually that one person introducing everybody else. So, but today, Gabriel, tables have turned and it's finally his time to shine. So, Gabriel, as we are beginning our first session, we are all ears. Please, the floor is yours. Thank you.
Thank you so much, Tunsu, for that very graceful presentation. And at one moment, I thought you were going to use the famous words of former South African President Jacob Zuma, who was once asked to read a verse in the Bible, and he said, "In the beginning." But luckily, you said, "In the beginning," and saved me a ton of laughter. But a very good afternoon, friends joining us from across East Africa. It's really a great honor to be here this afternoon to have this very wonderful discussion on the death penalty. And like a dear esteemed moderator also has said, this is the week that we commemorate that particular subject matter. So what we are here to confront is a question that will strike the heart of law, morality, and of human dignity. Because when you talk about life, you're talking about the right to it directly links into human dignity. So the question that stands today, friends, is where does East Africa stand on the death penalty? And of course, as you may know, in the course of our discussion, we'll not only be discussing statutes, but we'll be discussing issues to do with identity, values, and societies that we aspire to be. So today, this afternoon, I'm going to discuss the landscape of the death penalty in the East African region. And in particular, I would like to start by saying that across the region, the landscape of death penalty is complex and it is revealing. Revealing and complex, why? Because in some countries, abolition has been enshrined in the laws. For example, I can give you a case of Rwanda in 2007 and Burundi in 2009, when both countries chose to abolish the death penalty entirely. Now, I would argue that these were not just symbolic acts. They were deliberate choices that were made by these governments to ground themselves and have the moral courage and the belief that justice can exist without state-sanctioned killing. And that was a very bold move coming from Rwanda and Burundi. And if you look at the history of both countries, these are countries that had historically suffered from the claws of violence, and they realize the importance of the right to life. And one could argue that is why perhaps both countries chose to have this abolished by their laws. And of course, then there are nations where the death penalty exists in law, but not in practice. I can give you an example of our brothers in Kenya and Tanzania who have not executed a single soul in decades. For example, in Kenya, you've seen Supreme Court cases versus the Republic, and Muruateu versus the Republic, that mandatory death sentences, insisting that justice must be individualized and proportional. And so these just judicial interventions have become a bedrock for reform, even when legislatures have hesitated. I know in other countries, one could argue, like my motherland, Uganda, a nation that is at a point of bittersweet because it both demonstrates progress and peril. Because at one point in Uganda, you feel you are progressing, and at another point, it's more like a peril, more like regressing. Most of you heard of the Ugandan Anti-Homosexuality Act. It was another classic case that Uganda has moved on from the clause of having the death penalty. You saw in the law a reintroduction of the death penalty for certain aggravated, and I say aggravated offenses that relate to homosexuality. This bearing in mind that the Law Revision Miscellaneous Amendment Act sought to reduce pretrial detention periods. Now, this juxtaposition, procedural efficiency alongside reintroduction of capital punishment is a stark reminder for us that progress is never linear, okay? Our gains in this struggle can be fragile, and thus vigilance, ladies and gentlemen, is very essential as we discuss this matter for going today. So in my response to this topic that has been allocated to me, the map of East Africa is it. We have countries that have outrightly abolished the mandatory death penalty or death sentence, while some have moratoria in practice, and some have laws that fluctuate between reform and regression. Also, please confirm if you can hear me.
I cannot hear you, Gabriel. Thank you.
You can hear me now.
Yeah, sure.
Yeah, thank you. So I was saying that the map of East Africa is grossly varied. Some countries have abolished this mandatory death penalty outrightly, while some have a moratoria in practice, and some laws that fluctuate between reform and regression. So there's sort of a push and pull regarding this subject matter. The reaching trend is clear. The momentum favors restraint, reform, and ultimately abolition, where we are running to current context that we are. And so as I move on to my next discussion on my slide, which is the lessons that we have had from the field. And as you may know, we've had decades of advocacy, we've had decades of research, and a wealth of precedent from legal practice. And several lessons have been outlined and unmistakable. The first one, courts are agents of change. Through strategic litigation, we have seen that litigation has often preceded legislation. In countries like Uganda, countries like Kenya, we have seen careful constitutional reasoning, reaffirmed human dignity, and limited reach of this penalty. Courts in this context and the current times have not been mere arbiters. but in more of moral actors, which in a way you could argue, like the way I did this afternoon, that courts have been agents of change in this narrative. Secondly, the narrative that we sell out there really matters. Legal principles we've seen alone rare sweat. So what resonates are human stories, the wrongful convictions, the decades spent on death row, and the families that are often left in anguish. And this is where advocacy humanizes the law, that speaks to shared values and carries far more weight than just abstract arguments that can be made in every courtroom. Thirdly, political courage is indispensable. Our leaders often fear being seen as soft on crime, and I put soft on crime in quotes because most leaders are populists who always want to be politically correct on a number of issues. And yet, history teaches us that principled action can redefine societal norms. Rwanda and Burundi have clearly demonstrated that, like in my introduction, where I say that they abolished the death penalty. So Rwanda and Burundi demonstrated bold values and driven leadership that transforms law and societies alike. Fourthly, regional solidarity, and this is important. Speaking from a regional standpoint, regional solidarity will often amplify impact. So reforms in one country often inspire reforms in other countries. Just like I've said, the reforms that and Burundi made towards the death penalty have inspired or are in the process of inspiring sister states within the East African region, because this cross-border jurisprudence, civil society networks, and regional human rights mechanisms create momentum that no single government can ignore. So moving forward, what's the path forward? So what should we do to accelerate abolition across East Africa? Now, I argue that we must continue with strategic litigation, challenging the mandatory death sentences and procedural injustices. Friends, colleagues, ladies and gentlemen, in this platform today, I know majority, or if not all of us, are lawyers. And I would like to encourage a spirit of strategic litigation, because strategic litigation is the bedrock or the litmus test that we give to our different governments or constitutional structures in streamlining them to international principles and best practices cross border. So I would like to just to continue with strategic litigation. Let's continue challenging that penalty and injustices that exist within the structures. Secondly, we must engage legislatures and codify abolition and prevention regression. And this is where I call upon any legislature that is listening to us this afternoon. If you're a legislator at any level, please, we are calling upon you. Please let us codify abolition and let's prevent regression. I speak this for the case of Uganda, where we seem to be making one step forward and making two steps backwards with this abolition campaign over the years. Thirdly, we must engage and educate society and our faith communities. We need to abolition as consistent with African values of peace, mercy, and community. When we talk about Ubuntu, Ubuntu is an African principle of together, of brotherhood. That is what we should be calling for. Let's re-educate ourselves. Let's re-educate societies, frame abolition as consistent to our values. As Africans, values are we believe in the right to life, a right to livelihood. So why should we go ahead and keep quiet while people are being executed? Fourthly, We must institutionalize humane alternatives, including life imprisonment with review, rehabilitation, and restorative justice frameworks. Let us think about these humane alternatives rather than looking at execution. An eye for an eye will not bring justice. An eye for an eye will not solve the issues in the world. And then, of course, fifthly, let's leverage on regional and international instruments, such as the second optional protocol on the ICCPR to anchor reforms and signal leadership in this battle. Now, Uganda's 2023 legislative landscape is a stark reminder, a reminder that progress can be tenuous. Procedural improvements may coexist with retrenchment in certain areas. So, friends, for abolition to endure, it must legislatively be entrenched, culturally embraced, and institutionally safeguarded. My personal reflection, and it's a story that I keep sharing oftentimes. I have a strong background from the legal aid sector. Previously, I worked with the legal aid project of the Uganda Law Society, and we had a prisons project. And on one of these prisons visits, I met a man who had spent over years on death row for a crime that, of course, he says did not commit. And when he was finally exonerated at a later stage on appeal, his words to me were a reminder of how gruesome this can be. Hearing a man say the law could have killed me, and no law can bring back what it nearly stole. Reflect on that for a minute. That you can have a law because of maybe a poor judgment or poor evaluation of evidence leads to the death of an innocent man that no law will bring back to life. Let's think about that. Let those capture the moral narrative of our work. The death penalty is irrevocable, humanly fallible, and abolition is not an abstract idea. It's a matter of justice and humanity. So friends, again, like I began, where does East Africa stand today? We stand at a threshold of history. The currents of judicial courage, advocacy, and moral conscience all favor one thing, and one thing only, that is reform. The death penalty should be more than a legal instrument. It's more than that. It's a mirror of our collective moral state. When we choose to stand a decade from now, when East Africa is recognized for whom it punished, and how it chose justice and moral leadership, the question will be, were we able to let abolition be our mark of courage, our affirmation of humanity, or we let it be our legacy to future generations? As and give my colleagues an opportunity. This penalty, I could argue, is a lake of fear, and abolition is for conscience. Let us lead the charge as East Africa. I thank you so much to Berege for giving me this opportunity, and I'll take any questions. Thank you.
Well, thank you so much, Gabriel. That was a really eye-opening presentation. And I've been following and, getting into it. So I really have like two questions for you before I read Actually, no one has typed any question yet. Please, members, participants, you're allowed to write any question that you might have on the chat box. But well, Gabriel, you mentioned that the law exists. I mean, it exists in law, but not in practice. And given a short overview that you have given us, we can recall that Tanzania hasn't carried out execution since 1994, if not 1995. And yet, when you read our laws, it still retains that penalty. So, in policy terms now, would you consider this abolition in practice a stepping stone, or would you consider it as a stumbling block towards full abolition?
Yeah, thank you so much, Tunsu, for that very wonderful and well thought out question. Well, I could easily argue that Tanzania's situation can be viewed both as a stepping stone and a potential stumbling block, depending on how policy and advocacy are leveraged. On one hand, the cessation of these executions demonstrate a de facto commitment to restraint and respect for life. It creates a political and social reality which the state can no longer actively enforce this ultimate punishment. Of course, this can normalize abolition and provide a foundation for legislative reform. But in this sense, abolition in practice is a critical stepping stone. It allows our policymakers to observe the effects of non-execution over time. It will also the fear of political backlash and laying the groundwork for a codified abolition. On the other hand, one may argue the death penalty in law, it carries symbolic and practical risks. Some could say it allows for potential regression if political priorities shift and the public that execution is only a legal option. Some may argue like this. Of course, this will hinder the broader abolition movement by embedding ambiguity into our legal system. So without deliberate legislative follow-through, de facto moratoria can become comfortable complacency, and it will show momentum towards full. So therefore, to answer your question, the key is to translate abolition into abolition in law. And advocates must use the de facto as evidence that society can function without executions. Of course, while simultaneously pushing for legislative codification, ensure permanence and prevent backsliding. I hope that answers your question.
Well, Gabriel, it really does. And if I go to a point properly, it's like you have just reminded us that jurisprudence is moving, but it seems like the legislations are taking a nap somewhere. And actually, I really want to thank you very much because I had two questions, of which you have already answered them both. Of which my second question, if you'll just have a simple answer in the interest of time, was just from your between the judicial courage and the legislative hesitation. Like, my point is, how can this regional collaboration help bridge that gap?
Well, thank you, Tunsu. And from my standpoint, I could argue that the gap between judicial courage and legislative hesitation is both structural and political. Courts, and this I say, let me actually narrow it down. Courts, particularly our constitutional courts, operate within a framework that allows them to interpret fundamental rights, life, dignity, and fairness in a way that can act immediately to correct injustices. Judges are often insulated to some degree from short-term political pressures, which allows them to make decisions, such as striking down the mandatory death sentences, even when such rulings appear to be very unpopular. And when you talk about the legislature, on the other hand, these are deeply entangled in politics. Our lawmakers are only responsive to public opinion, elective cycles. Like now, two countries, Tanzania and Uganda, are going through the elective cycle. And so issues that matter, like abolition of the death penalty, are seen as politically risky in some of these communities at such moments, that courts even have oftentimes demonstrated the moral and constitutional necessity for this reform. And our legislators, of course, given that they are representative of our societies, and it's vox populi, vox dei in most of our communities, our legislators often lack technical data and human story, judicial intervention, and so they are hesitant to often act decisively. But there's a silver lining in the cloud. Regional collaboration can help to bridge this gap for us in multiple ways. One, to mention quickly, is cross-border judicial exchange. Like I mentioned earlier, sharing best practices, sharing jurisprudence from neighboring countries can give these legislators confidence that reform is feasible and respected within the regional legal ecosystem. Two, our civil society networks need to approach in a coordinated manner. We need to have informed research and regional examples that can shift public and political narratives in favor of abolition. Sometimes because of uncoordinated advocacy campaigns, we are able to persuade and win over the populace to jump on the bandwagon in favor of abolition. Thirdly, and most importantly, regional instruments and engagement of bodies like the African Commission on Human and People's Rights or the East African Legislative Assembly provides normative frameworks that legislators can or should adopt without fear of isolation. So ultimately, Tunsubilege, in conclusion, collaboration will allow for knowledge transfer, political cover, and moral legitimacy, creating an environment where legislative reform can catch up with judicial leadership. I hope that answers your question, Madam.
Thank you so much, Gabriel. You have just given us a powerful regional overview, and that was sharp as always. And as we are moving forward, John, I would like to welcome Advocate William from Palais. The floor is yours. Advocate William. William, I think you have to unmute. We cannot hear you, and I can see the mute button is still muted. Thank you.
Thank you, Tunsu. I'm sorry, I didn't unmute. So I was saying thank you, Gabriel, for setting the tone. This is a very important discussion, and it is an honor to join this important discussion on ending the death penalty in East Africa. And I will focus on the African and international jurisprudence, how they have advanced the right to life, and of course the implications on the region. Just by way of setting the context, the right to life is a cornerstone of all human rights. You cannot exercise any other right if you are dead, if you have no right to life. So this is a cornerstone of all other rights. So we are discussing a very pertinent issue here on the right to life. And if I may say that generally, African jurisprudence has really taken, there's a progressive human rights centered manner in which the continent is moving as a continent. Of course, there are challenges at the national level, but as a continent, the regional organs are making progressive decisions on the abolition of death penalty. If I may cite a few decisions, regional decisions, the African Court decisions and the African Commission decisions. May I start with the Ali Rajabu case? Ali Rajabu and others versus the United Republic of Tanzania. This is a case that I litigated, and I always am very humbled to talk about it because it's a case that really set set in motion the declarations of the African Court on abolition of death penalty from the statutes of the national states. So this was a case of the case of Ali Rajabu was a Tanzanian case, and it involved 5 people. And after the national procedures were concluded, that is after the Court of Appeal of Tanzania had made its decision, the parties, the Ali Rajabu and his colleagues were not satisfied, so they approached the African Court, and they asked the court to find that by the state of Tanzania having a section of law in its penal code providing for mandatory death penalty, that is an infringement of the African Charter. Now, that is what we argued before the court, and we successfully argued that. And in the end, the court made a decision that the responding state, that is the Republic of Tanzania, should undertake the necessary measures to repeal from its penal code the provision for mandatory imposition of death penalty. So this was a landmark case, a very important case, and several other cases followed. Now, this is a very progressive decision because the court is not only making a declaration for abolition of death penalty, it is going to the extent of wanting sections of law on mandatory death penalty to be removed from statutes. This was not a decision for Tanzania alone. It is a decision that impacts the rest of the African states and possibly the rest of the world. And we shall see later the impact of that decision in other parts of Africa. So these are an example of a decision that shows that we are progressing in terms of abolition of death penalty in the continent. And the African Commission has also made several progressive decisions. The decision of Inter-Rights versus Botswana, and several other decisions. And therefore, these cases collectively demonstrate that there's a regional shift from retributive justice toward human rights-based interpretation of punishment, that you don't necessarily need to punish a person by imposing a death penalty, but you can provide other penalties. There's a famous judge in Tanzania who made a decision, who wrote in a judgment, and he said, this Justice Lugakingira, he said, by a state killing someone because he killed another person, that is a knife for a knife. And if that is the case, then even a rapist, someone who raped, the state should also hire a special rapist to be raping, because if the only option is an eye for an eye. So that statement from that judge tells us you don't necessarily need to inflict the same action done by a person on the victim, because there are other options. Now, let me talk about the impact of this judgment and other judgments, of course, of the African court. Yes, we know we have challenges in the implementation of the African court decisions. Tunsu Bilege talked about several judgments not being implemented, and my judgments, Ali Rajabu and other judgments of the African court have not been implemented in Tanzania. Now, even with that, the fact that we have that jurisprudence of the African court making clear declarations that mandatory death penalty is a violation to the African Charter, that is a good point, a good starting point for advocacy and other initiatives toward death penalty abolition. And we can cite a few examples of the impact of these decisions of the African court in the national states. And a good example is Kenya. In the case of Francis Karioko Muruatetu, I know Gabriel also mentioned it. The Supreme Court of Kenya declared that mandatory death penalty is unconstitutional, and emphasized that sentencing someone to death is an abuse, is an abuse on the right to dignity. So that is a very good decision of the Kenyan court in 2017. And then in Uganda also there is a case of Attorney General Mr. Susan Kigula and others. The Supreme Court of Uganda took the same direction. And then in Malawi, the case of Kafanta Yeni and others versus the Attorney General, the High Court of Malawi made a similar conclusion. So there's a good, there are few countries that are moving with the pace of the jurisprudence of the African court. We have those examples. Now, if I may turn to the international perspectives, and on this, I will particularly cite the ICCPR, the international convention, and so the international convention talks about the rights of people, but the second optional protocol to the ICCPR is more particular, is aimed at abolishing the death penalty. Now, what we are struggling with this second optional protocol is that states have not acceded to this protocol, and maybe what is most important, most critical as we advance, as we undertake our advocacy efforts in the region, is pushing states to accede to this protocol. And this is critically important. For example, for Tanzania, we talked about non-implementation of the decisions of the African court decisions. And one of the reasons that Tanzania provides is that even the ICCPR allows for death penalty. But the second optional protocol is abolishing it. Now, Tanzania has not ratified the second optional protocol. So that is a problem. So much as the second optional protocol provides for abolition of death penalty, but most states have not ratified. Now, what do we do in terms of moving forward? One, I would think about advocacy. Advocacy, that is the job of us, CSOs, bar associations, and human rights advocates. We need to continue advocating on building on the existing jurisprudence to advocate for the abolition of death penalty, advocating in our national courts. We already have a good legal framework at the regional level. We should bring it down to our national courts. Another thing that we need to do is strategic litigation. We have seen the impact of strategic litigation. It helps. So let us continue strategic litigation for the abolition of death penalty. Of course, death penalty, this is about taking the right to life away from someone. Most constitutions safeguard the right to life. The Tanzanian constitution, for example, safeguards the right to life. So most constitutions safeguard this right. We should push for the accession to the second option, to the second optional protocol to the ICCPR. So this again is our job. We advocate and push for the states to accede to the second option to the protocol. Now, another thing that we need to do, and this is my observation, advocating for total abolition might meet resistance from the states. For me, I would propose that we start for abolition of mandatory death penalty, and then we shall go for total abolition later on. But for now, we can start with mandatory abolition, and then we continue advocating for total abolition. Now, that said, in terms of conclusion, at this point, I would say that the African jurisprudence is very progressive. We have, the African court has laid a good foundation. What is remaining is the political will, and we have the duty to continue pushing for the legislators to legislate on this matter in a manner that positively favors the victims of you know, victims of death sentences. So if I may end there, thank you.
Well. Thank you so much, Advocate William. And listening to you, one feels that African judges aren't just applying the law. They are quietly rewriting what humanity means in the courtroom. And listening to you also got me thinking that they're not only just applying the law, but they're writing its moral vocabulary. And for those who are joining us, we are on our second session. We started with session 1 that was grounding this conversation, where we highlighted the status of the death penalty in East Africa, like where does East Africa stand? Now we came to our second session, that is the Africa and international jurisprudence on the right to life, because now this is the heart of our discussion. Jurisprudence is the heart of our discussion. So as presented by William, thank you so much, Wakili. That was on the African perspective. And dear participants, thank you so much for your questions. I am noting them down and will be answered in a few. So I would love to welcome our next speaker, who is Mr. Geoffrey Mayamba. He will be taking us through the international jurisprudence, as we have already seen in the African jurisprudence with a little bit touch of international, as well explained by Advocate William. Mr. Geoffrey is the Executive Director of Prisoners Future Foundation in Zambia, as I introduced him at first. And also he's a member of the World Coalition Against Death Penalty Steering Committee. His country, Zambia, has recently made history by ratifying the second optional protocol to the ICCPR. So Geoffrey, welcome and congratulations again on Zambia's milestone. The floor is yours, sir.
Thank you, and thank you very much for putting up this interesting subject, which is something that we have at heart. The session that I'm going to participate in is session 3, Africa and International Jurisprudence on the Right to Life. My colleague has ably given me some hint on this subject matter. So my role would be to zero in on the status quo for Zambia. So Zambia's recent ratification is a landmark step. In December 2024, Zambia ratified the second optional protocol to the ICCPR, committing itself under international law to the permanent abolition of the death penalty. This ratification followed Zambia's domestic abolition of capital punishment in law, which happened in December 2022, marking a full transition from practice to legal and treaty-based abolition. So the key message that we can pick from this is that Zambia moved from de facto abolition to legal abolition and now to formal international binding commitment, becoming a leader in Africa and globally. So now, how has the international norm influenced Zambia? International human rights norms played a significant role in shaping Zambia's decision. For example, UN human rights frameworks did push Zambia to arrive at a decision which it took. So Zambia is a steady party to the ICCPR, which recognizes the right to life as contained in Article 6 and heavily regulates the use of capital punishment. Like seen in the ICCPR's respect for life in Article 6, a similar article in the Universal Declaration of Human Rights, Article 3, the right to life is also amplified. So Zambia's ratification of the second optional protocol aligns with the repeated UN General Assembly resolutions calling for a moratorium and pressure from treaty bodies like the Human Rights Committee encouraging formal abolition. Another example that influenced Zambia is the Universal Periodic Review, UPR recommendations. During past UPR cycles at the UN Human Rights Council, Zambia received multiple recommendations to, for example, abolish the death penalty in law and ratify to the ICCPR second optional protocol. So ratification shown Zambia's commitment to following through an international review mechanism. Another example is the global and Africa region momentum. More African countries have abolished the death penalty recently, including Zimbabwe in the southern region. This creates a norm cascade where increasing members of countries abolishing the death penalty creates moral and political pressure for others to join. The African Union and African Commission on Human and People's Rights, like we've heard, have also pushed for a regional protocol on abolition. There is also an aspect of peer learning and regional influence. So from this one, we will learn, for example, from lessons of the neighbors around the region. Zambia observed and was influenced by the experience of countries like Rwanda, Burundi, like we heard, Mozambique, and South Africa, which successfully abolished the death penalty in law, maintained the internal peace and order, but also received positive international recognition and support. Therefore, we also saw some kind of peer influence coming from civil society organization in Zambia with support from the global networks like the World Coalition Against the Death Penalty. We have seen, or we saw, public education and engagement, drafting of reports to the African Charter on Human and People's Rights, mobilizing political support for abolition. In terms of the region's leadership and its image, Zambia moves its position at a regional role model and strengthens its human rights leadership credentials. It may influence neighbors like Malawi. Others like Kenya, Uganda, Tanzania can learn from what Zambia has been through, which countries still retain the death penalty in law but have long moratoria on partial reforms. So what are the lessons that we derive from this Zambian case study? From this case study, we are able to tell that political leadership matters. Zambia's abolition and ratification were driven by political will at the highest level, including presidential support and parliamentarian action. Strong leadership can overcome public resistance or inertia. So now, as we mount the campaign against the death penalty, one of the things that we need to do as advocates, as civil society organizations that are driving this agenda, is to ensure that we identify ourselves with a political leadership. That way, we'll be able to exert pressure, because these have, to a larger extent, a role to play in ensuring that there is law reform. Legal reforms and international law go hand in hand. Domestic abolition laws are vulnerable without treaty ratification. Ratifying ICCPR OP2 locks in abolition and signals irreversible commitment. We have heard the example of Uganda. After they've been on Mauritania for so long, only to reintroduce death penalty for the kind of offenses that we hear. So with that said, we need to encourage organizations or country states that have already abolished in law to push for the ratification of the ICCPR on the second optional protocol. That way, they will be ensuring that there is no reverse of some sort that has to be made to that decision. And so we also have international credibility and cooperation benefits that Zambia has continued to enjoy based on its ratification. The position for Zambia in terms of international standing seemingly looks good, improving opportunities for human rights cooperation, development aid, and diplomatic influence in multilateral space. So, like the last presenter did mention, to go for a full demand of the death penalty may be a bit challenging, but to move step by step would be the sure way to achieving our goals. For the example of Zambia, they moved step by step from moratorium to legal abolition and now to ratification. Other countries, therefore, can follow a progressive path based on national readiness. We have seen, for example, Zambia hosted 2 years ago the parliamentarians from Malawi who came and learned on how Zambia managed to move onto this trajectory. They were able to meet Minister of Justice, the judiciary, human rights bodies, CSOs, and Minister of Home Affairs. They were accommodated, and a lot of questions that pose fears to politicians were brought out and answered ably. And the last step was that of taking them to Mukobeko Maximum Security Prison, where there is an execution chamber. When they viewed the execution chamber and how it is operated to take a life of an individual, the majority of them confess that we are doing disservice to our own people and our own countries. And we only hope that with the election of the new president, this is something that would be pushed so that we move towards the regional abolition of the death penalty. I think I'll end here for now. Thanks so very much.
Oh, well, Mr. Geoffrey, thank you so much for that powerful presentation. And your story proves that abolition is just not a foreign idea. It's an African achievement. And allow us to congratulate you once again for that brilliant achievement. Now, colleagues, from all we have grasped so far, it is clear that while the law gives reform in its structure, advocacy gives it its soul. So it's as if I'm saying the law is the brain of abolition, heartbeat, which gives pulse and keeps the justice alive. So with that, allow me to welcome you all in our last but not least session, where we are going to talk about advocacy, about awareness and public mobilization. The key focus of this session will be to examine what advocacy approaches have succeeded or failed, the role of CSOs, the role of media and faith-based actors. And with us, we have Ms. Rose Ngunangwa from TAMCOD and Okot Robert from HRA. Now, without no particular order, I would like to welcome Madam Rose, ladies first. Madam Rose, you're welcome. The floor is yours. Take us through. Thank you so much.
Okay. Good afternoon, colleagues. My camera does not want you to see my face, but I'll make an attempt. Let me go straight to the presentation. As mentioned earlier, most of the colleagues have mentioned some of the issues that have been helpful. I would say for the past 20 years or so, civil societies, the media, critics, and everybody else have been campaigning against the death penalty. And in a nutshell, have been to achieve a lot of milestones, but I would mention the media campaign in particular, because the law reform thing, the legal reform, has already been mentioned by my colleagues. In regard to the media campaign, in the past, we have been able to engage with a journalist, with editors, with several media outlets. We've been using blogs and social media to campaign against the death penalty. CSOs in numbers have been issuing press statements, public engagement, and all that. And we cannot say all has been in vain, because according to the Tanzania Human Rights Report of 2024 by the LHRC, Legal and Human Rights Center, the number of people who are convicted or who are sentenced to die has been going down. For instance, in 2020, 30 people were sentenced to death. In 2021, 24 people were sentenced to death. In 2022, 44 people were sentenced to death. And it was in that very year that the Tanzania Media for Community Involvement embarked into a huge media campaign to campaign against the death penalty. We made a call for judges to use their discretion to hand over life imprisonment sentences instead of the death penalty in capital offenses, because we told them, we advised them that records show or indicate that courts do, it can actually make mistakes, a chance that could see innocent people pay for the crime that they did not commit. We also conducted an interview, TAMCOD conducted an interview with a person who had spent 18 years on death row only to be acquitted or to be found innocent, that he did not commit the crime. And that guy made a plea to the president of the United States, or made a plea to the President of the United Republic of Tanzania not to sign any death warrants on account that doing so could see a lot of innocent people die. And as a result, I would say the joint campaigns, the litigation, the media campaigns and everything else. So again, people in 2023, the number of people who were sentenced to death were 37. And in 2024, 10 people were sentenced to death. Now, if you check the numbers, 30, 24, 44, 37 to 10, I would say the number has gone down abruptly, and it's well. And according again to the Tanzania Human Rights Report of 2024 by the Legal Human Rights Center, there are at least more than 700 people are on death row in Tanzania. Again, getting statistics and data has not been very easy, but at least the Tanzania Human Rights Report does guide us at least to see how the situation is. And the other impact has been that so far, Her Excellency the President of the United Republic of Tanzania has not signed any death warrants. And in 2024, President Samia Suluhu Hassan commuted 20 death sentences to life imprisonments. But apart from that, the Tanzania Commission for Criminal Justice proposed upon the need for the government to convert capital punishment for life imprisonments to inmates who serve on death row for more than 3 years. They also advised the government to review, or to rather scrape away, the death penalty and review its penal code. But the good news, again, the best is yet to come, is that we have had more high-ranking officials who have issued dissenting opinions in regard to the death penalty. We have Honorable retired Justice Karamba, who has maintained that the death penalty is a revenge business. Honorable Justice Angela Kileo, they're all retired, has said judges are humans and mistakes do happen. Death penalty is irreversible, and there are chances that such mistakes, irreversibility, could lead to innocent people being convicted to die and to pay for a crime that they did not commit. We have had Honorable retired Justice Ruhangisa. We have had former Prime Minister of Tanzania, Honorable Mizengo Pinda, who in 2023 also called upon the need to scrape away or to do away with the capital punishment, Justice Werema. And on top of that, in October 2023, the government, through the Minister of Constitution and Legal Affairs, through its minister, again, Pindichana, Honorable Pindichana, said Tanzania was considering abolishing both capital punishment following interventions from the African Court on Human and People's Rights. And this is quite something, a very powerful move from the government, from the retired justice and all that. Now, on way forward now, I would say we need to enhance advocacy campaigns and engage with the judges to enable them to use their discretion to sentence people charged with murder to life imprisonment. We need to convene a national dialogue with anti-death penalty campaigners, prelates, traditional leaders, MPs, prison wardens, those acquitted, prominent government officials, judges, lawyers, journalists, and all like-minded organizations, the law reform to push for amendment of Section 197 of the Penal Code, so that it cannot tie, because in all the interviews that I've conducted with the retired justice, they've complained that at times some of them hand over death sentences unwillingly because they feel that their hands are tied by the Section 197 of the Penal Code. But towards the constitutional reform, we need to push for a provision to scrape away the death penalty in the country books. Unfortunately, we did a lot of campaign during the constitutional review, but the first proposed constitution review process and the first and the second constitution, proposed constitution, all did incorporate an aspect calling for the death penalty, to retain the death penalty in what was supposed to be a new constitution at the time. But now, since we are told that the new constitutional reform will come back again, we need to push for that, to make sure that the new constitution does protect the right to life completely without any draconian pieces to infringe the same. But we also need to engage in campaigns, push for the Minister of Health and other stakeholders to invest more on mental health, to curb these killings that we have been seeing. but we also need to invest in research and keep a database of people who are sentenced to death and those on death row for advocacy, because without data, we cannot make any other decision. And in regard to what else should be done, TAMCODE, for instance, to maintain the momentum, TAMCODE has a loose network of journalists against the death penalty, but could not move on forward due to funding, although it still maintains strong ties with the media, such as the IPP media, the standard newspapers, bloggers, and we've been engaging them, and the team has been very vibrant. We need to maintain the campaign to keep the momentum up, because the power of the media is mightier than that of the bullet or that of the sword. We also need to create messages with these influential people, use them as our influencers, those key government officials, key religious leaders, the retired justices. We need to create some powerful messages, air them through radios, TVs, create some posters and brochures to campaign against the death penalty. We need also to gather more voices from those who are wrongfully convicted to issue testimonies, which will be aired through radio programs, and to make sure that we change the public perceptions towards the death penalty. But above all this can be done with jointly fundraising strategies. We need to fundraise. We need to make sure that the anti-death penalty campaign is not a one-time thing. It should not be only for October. We need to maintain the momentum, to keep up the pace, to keep going throughout the year. We engage in various activities, and only then would we be able to achieve the results that we would wish. Having said so, thank you. I can return the platform to you, Madam Moderator. Asante sana.
Thank you so much, Madam Rose. That was a powerful presentation. And now before I ask my questions, I would like to welcome a man who has made advocacy an art form. Mr. Okot, the floor is yours for the next 7 to 10 minutes. You're welcome, sir.
Thank you very much, TM. I choose to call you TM because your name seems to be very, very long, and I don't want to violate or to murder your name.
It's okay, thank you.
Yeah. Thank you very much once again, East African Law Society and the panelists on board. I've been asked to talk about the role of civil society and advocacy. But before I even get into that, because I want to use the experience of Uganda to send this message home, I would like to start with the Susan Chikula case. And in 2003, Foundation for Human Rights Initiative, a non-profit organization in Uganda, filed a petition on behalf of all prisoners on death row challenging the constitutionality of the death penalty. Now, the petition argued in the first instance that the death penalty was a cruel, inhuman, and degrading treatment and punishment, and was therefore inherently unconstitutional. It was also argued that the mandatory death sentence was unconstitutional and that execution by hanging was an unconstitutional method of execution. The petitioners further argued that the long delay between a sentence and execution made an otherwise constitutional death penalty unconstitutional. Of course, the Constitutional Court held that a mandatory death sentence violated the right to a fair trial by denying a proper sentence hearing and precluding the appellate review of criminal sentences, and violated the principle of separation of powers, and that any inordinate delay lasting longer than 3 years would be unconstitutional. The court, however, held that the death penalty in itself is constitutional. And what did the court order? For the petitioners whose appeal process was completed and their sentence of death had been confirmed by the Supreme Court, their redress would be put on hold for 2 years to enable the executive exercise its discretion under Article 121 of the Constitution. And they could return after expiration of the 3 years. And for those appellants that were still before an appellate court, they would be offered a hearing on mitigation of sentence. The court would exercise its discretion whether or not to confirm the sentence, and irrespective of those whose sentence of death would be confirmed, the discretion under Articles 121 had to be exercised within 3 years. I have represented some of the beneficiaries of this case, but the Attorney General appealed the decision to the Supreme Court. And of course, the Supreme Court dismissed the appeal and upheld the decision of the Constitutional Court and added some modification to the Constitutional Court judgment. And it stated, for those respondents whose sentences were already confirmed by the highest court, their petition for mercy under Section 121 of the Constitution has been processed, determining that before decision is made by the executive, the death sentence shall be deemed commuted to imprisonment for life without remission. And for those respondents whose sentences arose from the mandatory sentence provisions and are still pending before an appellate court, their cases had to be remitted to the High Court for them to be heard only on mitigation of sentence, and High Court may pass such sentence as it deems fit under the law. But what was the impact of this judgment? It restored judges' discretion. Judges are no longer bound by law to hand down the death penalty for capital offenses. They can now exercise discretion on the suitable punishment for each case. We now have sentencing guidelines as well. Yeah. And then you've now had a reduction of death row inmates. Because of that ruling, we have a number of people that have successfully appealed their death sentences. Of course, this judgment has been used as jurisprudence in the region. Tanzania borrowed a lot from that decision. And then, since it scrapped the mandatory death sentence, the second gravest punishment in Uganda is life imprisonment. Now, we may need to ask ourselves, why would an anti-death penalty campaign be faced with a lot of backlash? We still have most of our people supporting the death penalty. We still have a lot of crime rates. And then you have politicians publicly supporting the death penalty. All these just make the work for anti-death penalty campaigners harder. Yeah. But again, we need to ask ourselves, why should we abolish the death penalty? We are looking at deterrence. Of course, proponents of the death penalty often argue that the death penalty deters crime. However, when you look at the number of such, whether it's actually not good empirical evidence to support argument. Because most seem to think that not saying,
I'm sorry, Mr. Roberts.
Yeah.
Hello. I don't know if it's on my side or to everyone. We are losing you at some point. We cannot really hear you properly. Yeah.
Am I
Thank you.
clear now?
Now you're clear.
Yes. I was saying that why should we really abolish the death penalty? Number one, we need to look at the idea of deterrence. Of course, proponents of the death penalty argue that the death penalty deters crime. But when you look at studies that have been done around the globe, it actually shows that long-term sentences offer more results when it comes to deterrence. Yeah. So more of long-term sentences are opposed to the death penalty. And then when you look at rehabilitation, punishment is supposed to serve
Mr. Robert, we cannot hear you. You are breaking
I'm
so
saying that,
much.
am I audible?
Yeah, when you come close to the screen, you are more audible than when it's not close to the screen. Thank you.
Okay, I was saying that when you look at rehabilitation, punishment is supposed to serve, let's say, retribution, deterrence, rehabilitation, reconciliation, and restorative justice. But when you look at the death penalty, it mainly serves the purpose of retribution. And that's why some scholars have argued that long-term sentences could be a much better option as opposed to the death sentence. But getting back to what civil society can do, I have represented about 10 death row inmates. But all that has been efforts supported by civil society. Yeah. The case that led to the abolition of the mandatory death sentence in Uganda was supported by civil society. All that is advocacy. Now, the other things that civil society can do is to ensure that lawyers, judges, and other officials within the justice, law, and order sector are properly trained. Just after the Susan Chigula decision, one of the civil society organizations I worked for then embarked on a process of hiring lawyers to represent death row inmates or those that were supposed to benefit from that decision. To date, that organization still supports those efforts. And I can assure you that over 100 death row inmates have been helped have their sentences reduced from death to other sentences that are not death. And to me, that is already a bonus. Yeah. Judges have been trained. Of course, there are judges who are very conservative, and we had challenges in earlier stages, most especially high court judges. Yeah. And most of them would maintain the death penalty because some of the cases were supposed to go back to the high court to have their plea in mitigation. So you will always have such judges who are conservative. They still want to maintain a death sentence. About 2 years ago, I handled a case where someone was sentenced to death. on purely biblical standards. The judge quoted more of the Bible than the law. Yeah. And you could see that to them, this person deserved to be sentenced to death. Neglecting all the jurisprudence, all the developments after the Susan Chikula case. And mind you, this person had been on remand for about 4 or 5 years. Yeah. And by the time I was handling his appeal, it was now about 12 years. So you can really see that there is a lot of injustice that happens in here. But again, we don't have the assurance that our judicial system or our prosecutors are saints. They make no mistakes. Yeah. I have again handled another case where 2 gentlemen were sentenced to death. But when you look at the case properly, these guys actually had evidence that they were not on the crime scene. Yeah. But remember, most of the people that are charged with the offense of murder and finally or who get convicted, yeah, and sentenced to death are people that do not have means to afford an experienced lawyer. So they end up using state briefs. State briefs are given less than $200 to handle a murder case. Now, in that $200, how will someone be able to collect all that kind of information or to support the collection of all that kind of information? If civil society does not come in, it means that accused person will most likely be convicted. Yeah. And of course, there are a lot more other challenges. There is another case that I handled in 2024.
Mr. Court, sorry to interrupt. We are left with 2 minutes for you.
All
And
right. Thank you.
Yeah, as you're answering, as you are giving us a short history, I think it would have been best if you answer this question from Bronwyn, because you're talking about civil society organization. Bronwyn, she's asking, we see around the world, including on the African continent, long-term and official moratoriums on executions tend to be difficult to move away from. So often political will is limited to push for full abolition, and the country benefits from a positive abolitionist in practice. Stands from international perspective, are there any practical steps or guidance for civil society on how to encourage their governments to move to official moratoriums? Yeah, so I think as you're winding up, you could have.
When we talk about practical steps, when it comes to advocacy, you could engage diplomatically, like I had earlier on stated that one of the organizations I'd worked for trained lawyers just after the Chikula decision, letting them know the dangers of continuing to hand down the death sentence, letting them know about the developments around the world, yeah? And by the time such engagements were done, a number of them felt like the death sentence was no longer necessary. Of course, engaging with politicians is not easy because sometimes they are swayed by public opinion. So it's very hard for, let's say, a president in Uganda to openly come up and say, you see, we are going to put down the death penalty when the crime reports tell him that there is a lot of aggravated defilement, there is a lot of rape around the country, things of that kind. It is very hard, but you continue to engage. I think that's all from me.
Thank you so much. Thank you so much, Mr. Okot. Now, for the interest of time, I would like to welcome Advocate William to tackle some of the questions from the chat box before we finalize with our last session. Advocate William, you're welcome.
Thank you, Tunsu. Let me attempt a few questions from the chat box. There's a question which asks, don't victims of violent crime and families have the right to justice as they say an eye to an eye? Okay, I assume if the victim of violent crime, one of the victims is this person who now died, is the deceased. The deceased, justice for the deceased is for the killer to be punished. Now it could be life imprisonment, could be death sentence as the case might be, but that is what we are advocating for abolition. But the victim number one is the deceased who is dead, and his justice is for the person who caused the death, to face legal consequences by being taken to court and have a sentence put before him for what he did. Now, about the families, normally there are no compensations. And if I may expand a bit, the nature of criminal cases, the nature of criminal cases normally ends with the punishment, a penalty, a fine. And this is because normally in criminal cases, it is the state which is the complainant. So there are no normally monetary compensations in most cases. About the families, whether there is any justice, yeah, for the family again, justice is when the perpetrator has been taken to court to face the consequences of his actions. Normally, there are no monetary compensations to that. That is at the level of national courts in most states. But yes, that's normally the case. The second question is, what is a better sentence over death sentence? This is a challenging question. Challenging because of the experiences that we have had with inmates. I mean, those who are also on life imprisonment. Yes, the straight answer would be the better sentence is life imprisonment. That is a straight answer. However, even with life imprisonment, we have some inmates who are complaining that life imprisonment is also just bad because, life imprisonment means you have to wait until death finds you. Now, death may not visit you as soon as possible. It may take long, and it may give you a chance to live up to 100 years. Now, by the time you are 100 years, you cannot walk. You need someone to take you for a sunbath, and if they delay to take you back, to take you back, the sun will when the sun is now hostile, it will be on you. So there is that challenge that death may sometimes take long to visit someone who has been on life imprisonment. However, why we are saying life imprisonment is better, it goes down to the principle that no government has the right to take away what it cannot give. The government cannot give life. If it cannot give life, it cannot also give birth and death. I mean, it cannot take away life because it cannot give. It cannot take. It should not take what it cannot give. Therefore, that is the major principle. To be short, a better sentence would be life imprisonment. Another question is on if no EAC state has executed the death sentence, why are we arguing about abolition? Yes, that's a good question again. But we are arguing about abolition for several reasons. One of the reasons is, for as long as that particular section exists in our laws, chances are there might come a president or someone, because normally it is a president who refuses to sign. But chances are, what if a president comes who is for execution? He will execute. But number two, in actual sense, some executions are going on. Some executions are going on. Maybe it could be in a small number, but they are going on because that law allows it. So abolition is still important because we need those sections to be taken away to be taken out of statutes, so that there are no chances for anyone to impose death penalty, mandatory death penalty. Those are the few questions I wanted to attempt. Thank you, Tunsu.
Thank you so much, Advocate William. And as I was listening to you, the way you're tackling the questions, I actually also got a point. As Caroline asked, she phrased an eye for an eye. But now, if we follow that literally, as Gandhi warned us, the world would end up blind. Now, if it's an eye for an eye, who will draft the appeal if all of us are blind? So for my side, I feel like justice for victims is essential, but abolition does not mean leniency. It means that we are replacing that vengeance with responsibility. As William said, life imprisonment, for instance, it will ensure accountability without turning the state into what it condemns. So, and on about the public opinion, yes, sometimes people say they favor death penalty, but remember, the law's job is not to echo the crowd. It got me thinking during those periods when Jesus was on earth. If Pilato were here today, he would have told you and he would have reminded us that democracy works best when reason sits at the head of the table, not anger. So when we take anger ahead, I don't think if that will be a right approach. And to the second question, I would also like to cement. Raphael Shingisha asked on why abolition matters if no one is being executed. And it also got me thinking, oh, yes, please, I am an overthinker, don't judge. It got me thinking that it's fair for you to think that way, Raphael, and you are right. And we haven't executed it for years. But the law is still in the books. And quietly, it is waiting for that bad day in history. Just as Ernest said, sometimes might come a person that will actually sign, and the person will be convicted to death. You see, so you spoke also about deterrence, and studies shows that criminals don't check the penal code before committing a crime. So with that, if they did, I think I wouldn't have become an advocate today, because now what would have been my job? So yes, abolition is not about softness, Raphael. It's about consistency. If we value life, then the law must not contradict the value by threatening to take it, as William Ernest Kivuyo had just answered. And with that, I think, is there any other question that we have not tackled? Oh, I see Alfonsina is asking on lessons from Rwanda and Burundi. Like, can Tanzania learn from Rwanda and Burundi's experience without abolition in terms of public perception and outcomes? Oh, that's a brilliant question, Alfosina. Any panelists who would like to tackle that question, or I should just go with it? Anyone? Madam Rose, are you there? Okot? Gabriel?
Kindly repeat that question.
So the question is, can Tanzania learn from Rwanda and Burundi's experience without abolition in terms of public perception and outcomes? Like, could Tanzania benefit from learning army lessons from Rwanda and Burundi's experience with abolitioning the death penalty, both in terms of public perception and practical outcomes?
I think what I can say is that it's really a process. And that's where civil society comes in handy, in as far as ensuring that there is a lot more information within the public domain that tells people that, you see, in such and such countries, these are people like us, but they have decided to abolish the death penalty, facing politicians. Because you see, even if you file so many cases, for as long as the politicians have not grasped it within them that it is no longer necessary to have the death penalty on their law books for them to achieve the aspect of deterrence in crime. That's what I would say on that.
Thank you. Thank you so much, Okot. And with that, as I earlier said, I'm an overthinker, yeah. I think both Rwanda and Burundi, they have proved that abolition is not the end of justice. I feel like they just proved to us like it's the beginning of maturity in lawmaking. So as just a joke in abolition politics, they say the hardest thing to execute is not the prisoner, it's the old mindset. So from that view, I think we should firstly concentrate on changing these old mindsets so that we can mature. I'm not saying we are immature, but who knows? So with that, colleagues, we are on to our last, very, very last session of where we are going to look on the way forward. So I would just like to take these 2 minutes to welcome anyone, any member, even if you're a panelist, you're the participant, just you can raise a hand if you feel like there's anything, anywhere that we can do forward from where we are. We have seen where we are, where are we heading, what are the shortcomings, what should we do in the long run. So anyone, I would like to give you at most 2 minutes.
Yeah, hello.
Hello, Madam Rose.
Yeah, hello. Yeah, I think as I mentioned earlier, I may have gone perhaps too fast, but my recommendation were the same, that we need to keep the campaigns going on. It should not be a one-time thing. We need to come with a work plan that we'll be implementing throughout, let's say, 2 years or 3 years. But we also need to convene a national dialogue with all anti-death penalty campaigners. We've already identified some of them, members of parliament also who are charged with the law-making process, prison wardens to share their testimonies, because I once attended a meeting, a conference rather, on anti-death penalty campaigns in Kenya, and found prison wardens who were charged with pulling the rope, and they said, you know, it was tormenting to them. It was even worse, and they were very helpful in the campaign. I think we also need to engage religious leaders, traditional leaders, those who have been acquitted, prominent government officials, judges, lawyers, journalists, and all like-minded organizations, inclusive of the Law Reform Commission, because it's in records that the Law Reform Commission once conducted research to establish whether they should keep the death penalty or not, but the report was never released. But we also have some issues that have been aired in regard to the dissenting opinions, like the Nyarali Commission, like the retired justices that I mentioned earlier. I think we have somewhere to go through, but we should also engage in research, invest in research, in the database on people who are sentenced to death and those on death row for advocacy. We need to get as many voices as possible from those who were wrongly convicted but later on acquitted. Who were wrongfully convicted to die but were later on acquitted. Those guys could be a very instrumental in our campaigns, because it's always nice to hear from the horse's mouths. But what is even more critical is to engage, to continue with the media campaign. Let us continue with the media campaign, because again, the media, the power of the pen is always mightier than that of the sword. But as I mentioned earlier, all this can be done with joint fundraising. We need to come with a fundraising strategy. We need to fundraise jointly as a network to come with funding that will implement this as a project. It should be a project that will be ongoing to make sure that we get in a point where either the penal code could be amended, or we have a constitutional reform which will not incorporate the capital punishment in this country book. So those would be some of my recommendations for the of course, we need to continue with creating the messages. We could record messages with influential people who issue dissenting opinions. Those normally are very powerful. When somebody hears a judge, a former prime minister, or a religious leader, prominent religious leader, speak about the evil deed of the capital punishment, I think it's a very powerful message. With me, it's always the media campaign again and again, because that's my area. And as mentioned earlier, TAMCOD has a loose network of journalists who are always eager to work on anything on death penalty. The only thing so far has been, the only setback has been the lack of funding. But even without funding, we have been working together very well. But we believe with a little bit of a pat on the shoulder, I think we would move forward. Having said so, thank you again for this golden opportunity to campaign against this very important topic.
Very much thanks to you, Madam Rose. Anybody else? Just 1.5 minutes. Anybody else with anything to say?
Yeah, thank you, Tunsu, and dear colleagues, for this very wonderful discussion. My 2 cents on this, and I'm happy that somebody asked a question about it. Now, what we've seen going around the table is that this is not just ideals, but real steps. And thank you, Madam Rose, for outlining those real steps. Now, Tanzania stands at very fertile ground for this advocacy, as Tanzania has already paused executions since 1995. We've seen a lot of advocacy coming in from the African Court, pushing for reform through its judgments. And I believe right now is the moment to act for Tanzania and for the rest of the region. Somebody asked about Rwanda and Burundi. Yes, Rwanda and Burundi have led the way. They've illuminated the path for us. Rwanda has, in the past, used open community talks, open sessions to ease fears, proving life sentences work without, sparking crime spikes. Burundi, similarly, leaned on the side of civil society to build support and align with the African human rights goals. And I believe Tanzania and the rest of East Africa can borrow on those positive attributes that Rwanda and Burundi are leaned on to move towards a right direction. So for Tanzania, I think the plan for us is to, like Madame Rose said, national aggressive campaigns, town halls, radio shows, religious institutions, explaining abolition cuts and why abolition is the way to go. For example, cutting costs, freeing courts and opening doors for extradition, etc. I believe it is time for us to now pilot a law that replaces the mandatory death sentence with life imprisonment or something that is in the alternative. I've had William's submission and sentiments towards life imprisonment, but yeah, it's time to get alternatives using Rwanda's model of strict solitary terms for serious crimes. And for me, finally, we need to engage the 2023 Commission's findings to show the public support for commutation so that by 2026, Tanzania can be at the forefront of turning moratorium into a legacy of justice that is tough, fair, and human. Thank you.
Well, thank you so much, Gabriel Achaye, and esteemed colleagues, as we close, you know, I'm reminded of an African proverb that says, you can not really cover the sun with your hand. And this is to mean, just I will quote a Bible verse saying, when the time is right, I, the Lord, shall make it happen. So with that, I believe the truth is out and death penalty days in East Africa are numbered. So on behalf of the East Africa Law Society, TDPAC, and our partners, World Coalition Against Death Penalty, we would like to thank you all for your insights, for your energy, and your vision of justice, system that values life, as Nelson Mandela once said, to deny people their human right is to challenge their very humanity. So with that, let us continue to work, not just in words, but in deeds, because, you know, injustice anywhere is a threat to justice everywhere. So thank you, and may this conversation light the path to death penalty-free East Africa. Thank you all for your time. See you when it's convenient next time.
Thank you.
Bye-bye.
Bye-bye.
Moderation.
Bye.
Bye bye.
Bye-bye.
Bye.
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 Bye, your coach.